I want to talk about a unique alchemy of factors with a particular emphasis on the courts that contributed to the dramatic reductions in crime and incarceration. These are: 1, innovative policing; 2, public-private collaboration; 3, a vibrant infrastructure of alternative to incarceration programs; and 4, a major philosophical shift in the judicial role and mindset. Civic leaders, elected officials, and police chiefs have received the lion's share of attention for New York's decline in crime, and justifiably so. What is less well documented is the role that the courts played in that decline. As I mentioned earlier, changes in policing practices in the 1990s led to massive increases in our criminal dockets. Many of these offenders ended up being incarcerated, at least initially. Yet most of those cases were not major felony matters involving criminal masterminds, but nonviolent offenses committed by individuals with chronic problems like drug addiction, joblessness, mental illness, and homelessness. It did not take long before our traditional way of doing business, prison, jail, probation, reached the breaking point. Faced with this reality, we had a choice to make. We chose to look for new ways to respond to our changing dockets. In fairness, we did not start from scratch. New York has long been blessed with a vibrant network of alternative to incarceration programs like the Women's Prison Association and the Fortune Society. These and other nonprofits have been working with offenders and formerly incarcerated people for years, providing substance abuse treatment, counseling, career development, education, housing, and other services so that they could rebuild their lives and avoid further criminal behavior. It was a limited example, but it still suggested to some of us in the courts that alternatives to incarceration, if done correctly, were not just get-out-of-jail-free cards, they were good policy. But the consensus among judges and prosecutors in the early 90s was that we could not do it effectively on the massive scale that was required. Fortunately, some of us believed otherwise, even back then. We began with a handful of small targeted investments. In addition to dozens of problem-solving courts like these, today in New York there are 180 drug courts, more than any other state. They have given more than 56,000 offenders the opportunity to get clean and avoid prison time. Research has shown that these drug court participants are almost 1/3 less likely to commit another crime than similar defendants whose cases went through the traditional court process. The reductions in addiction and recidivism have had far-reaching effects. In human terms, hundreds of babies born to drug-free mothers and thousands of families reunited after being torn apart by addiction. In financial terms, the savings of nearly 2 million days of incarceration, when you consider that it cost an estimated $35,000 annually to keep someone in prison. New York's drug courts have saved the state more than $200 million in prison costs. The final lesson I want to talk about is, for me, one of the most interesting factors in the New York experience, one I have personally witnessed and marveled at: how the judicial role and mindset have changed dramatically in a relatively short period of time. But it is a lesson that many judges and court administrators of my generation had to learn the hard way. Of course, judges and lawyers are trained to respect precedent and tradition, and to regard the adversarial system as the great engine of truth. So it was not easy to convince them that traditional court processes had to be reevaluated and revamped. Not easy to convince traditionalists that an offender's underlying problems and needs are more than background issues in the prosecution, that they should, in fact, be put at the center of the court process, and that everyone, the judge, the DA, the public defender, must actually work together to change the offender's behavior through punishment and, yes, treatment and other needed services. This was a great, great departure from our nature of our view of the adversarial system. The first converts, not surprisingly, were the judges on the front lines, because they knew the bitter truth that they were accomplishing very little of lasting import by doling out short jail sentences, dismissing cases for time served, or simply passing offenders off to equally overburdened probation departments. Whether you called it assembly line justice or Mick justice, the sad reality is that judges were working hard, applying the law, getting through huge calendars, but making very little difference in the lives of defendants, victims, and neighborhoods. As I like to say, we were counting cases instead of making every case count. By contrast, in our drug courts and problem-solving courts, the judges evolved far beyond the distant, detached arbiter who managed the legal process, pronounced guilt or innocence, imposed a sentence, and then moved on to the next case. Rather, the modern drug court judge, the problem-solving judge, is a proactive, hands-on agent for change who views his or her role as an opportunity for the entire justice system to intervene, not only to punish the individual, but just as importantly, to achieve a better outcome for that offender and his family and for our communities and public safety. The judge is asked to look at each case and each litigant as a problem to be solved and not just another case to be processed. In this model, the court acts as the hub of the criminal justice process, linking to various service providers, staying involved with each case over the long haul, and using the judge's authority to promote compliance with treatment plans. The judge is the authority figure under this plan. Lawyers on both sides of the aisle have assumed new roles as well, not your typical adversarial roles, because problem-solving courts bring different parts of the system together to agree on who is eligible to participate in treatment, to come up with mutually agreeable systems of sanctions and rewards, and to figure out the best way to encourage offenders to succeed in treatment. When it comes to nonviolent crime, the bottom line is that we have changed how judges and lawyers measure success, no longer by the number of dispositions, convictions, and acquittals, no longer by which side wins or loses the case, but by whether we are able to break the cycle of addiction and crime and improve public safety in the process. When that happens, everyone wins. I am proud of what has been accomplished over the past 2 decades and proud of the significant role the New York State courts have played. But there's no resting on our laurels. We must be on the alert for new crime trends and new methods of promoting law-abiding behavior. We must respond to new problems as they emerge, and we must take care of unfinished business.